Many thanks to everybody for joining me. This is yet another in Farrar's Building webinar series. And today I'm going to be talking to you on a guide to personal injury claims involving limb loss. You will all no doubt be aware that April is Limb Loss and Limb Difference Awareness Month. And as such, I thought it was a good idea to focus this month's webinar on personal injury claims that involve limb loss. Just two matters of housekeeping before I do start. Firstly, I've tried to edit the slides so that if you are looking at my face, if you position it in the top right-hand corner of your screen, you should be able to see the slides without any difficulty. And now, of course, you may choose to minimize my face to enhance your webinar experience, and I won't know that, so that's fine. But if you do want to see me, then if you put me in the top right-hand corner, that's probably the best place. Secondly, there is a Q&A facilities on your system where any questions you have can be raised. I won't be monitoring that box during the talk, but we'll hopefully have some time at the end of the webinar to review any questions that are raised, and I'll do my best to answer them with the time that we have available. I say the time that we have available. What my plan is for the hour that I have afforded to me for today's webinar is to go through four things. First of all, I'm going to discuss or consider some examples of breach of duty that can lead to limb loss. I'm then going to go and give a brief consideration of contributory negligence where accidents have caused limb loss. And then going to move on to considering some of the common heads of losses that such personal injury claims can include. And then I'm going to give some practical guidance at the end for dealing with such claims. And that will hopefully be aimed at both defendant and claimants and from a defendant and claimant's perspective. So that's the aim. In terms of breach of duty, on the slide in front of you, there are some examples of the types of cases that can lead to limb loss. Obviously, that is not an exhaustive list, but the four most common causes of limb loss are workplace accidents, road traffic accidents, clinical negligence claims, and claims where there is disease or ill health arising from a breach of duty. I'm not going to be able to consider all of those types of breach of duty. So instead, what I'm going to do is I'm going to focus just on workplace type accidents that cause limb loss, mainly because there's been some recent cases and some recent relevant considerations to consider in the realm of workplace accidents, but also because that's an area that I have a particular interest in. Some basic examples of workplace accidents that can lead to limb loss are on this particular slide. Quite a common feature: failure to guard a cutting mechanism, failure to turn off rotating machinery. That example comes from one of my own cases, but also is what happened in a case we're going to come on to where we're looking at contributory negligence. Failure to prevent negligent use of equipment such as forklift trucks. Things of that nature can lead to accidents which then either involve amputation during the accident or lead to the need for an amputation later on. Of course, first thing to consider in any case is, first of all, whether or not the defendant owes a duty of care to the claimant. Secondly, what the standard of care is. Thirdly, whether that duty of care has been breached, and then whether or not that breach is causative. And it's only when you've gone through all of those features that you then go on to discuss and consider quantum. Of particular interest in workplace cases is the ongoing relevance or otherwise of the health and safety regulations. Now, in the past, in workplace cases, you would generally look to the relevant health and safety regulation to see what duty is owed, by whom, and what the standard of duty is within the realms of that health and safety regulation. Not so anymore. As everyone knows, following Section 69 of the Enterprise Regulatory and Reform Act 2013, breach of health and safety regulations no longer impose civil liability. So now any claim has to be brought in negligence. The duty on an employer in negligence is as it has always been, which is they owe a non-delegable duty to take reasonable care to protect employees' reasonable safety. If health and safety regulations had imposed on a defendant a duty of care to those other than their employees, for example, people working who are not an employee, but within their control, then it's very likely that that defendant will still owe that entity, or that type of person, a duty of care. For example, compare the work at height regulations 2005 with the personal protective equipment at work regulations 1992. The work at height regulations imposed a duty on employers to their employees and to any other person under his control to the extent of his control. Comparing that with the personal protective equipment at work regulations, that refers to duties owed by employers to employees, but no one else. So it's arguable that in negligence, an employer would owe a duty to people other than their employees if they have fallen off scaffolding, for example, and the work at height regulations set out the standard of care that would generally be imposed in that type of case. So that will be still an indicative of whether or not a duty of care is owed in the first place. And of course, employers will be owing duties under the Occupiers Liability Acts and in negligence anyway, if the Caparo test is satisfied. And as already touched upon, likely to owe duties to anyone within their control within the workplace to the extent of that control in any event. In terms of the standard of care, that is of a reasonable and prudent employer taking positive thought for the safety of his workers in the light of what he knows or ought to know. Now, the key part of that sentence is, of course, in light of what he knows or ought to know. Now, every employer ought to know about duties owed under the health and safety regulations. There have been some competing views on the extent of the ongoing relevance of health and safety regulations when looking at the standard of duty of care and whether or not they provide evidence of ipso facto negligence. In Cockerel and CXK Limited, which is a 2018 High Court case, Deputy High Court Judge Rowan Colin Rice considered the effect of Section 69 in the context of a tripping claim brought within the concept or within the construct of Regulation 12 of the Workplace Health, Safety and Welfare Regulations. She concluded that in removing, and this is a direct quote, in removing the claimant's cause of action for breach of statutory duty, the 2013 Act did not repeal the duties themselves. Those duties continue to bind employers in law. So they continue to be relevant to the question of what an employer ought to reasonably to do. However, by enacting Section 69, Parliament evidently intended to make a perceptible change in the legal relationship between employers and employees in this respect. It removed direct actionability by claimants from the enforcement mechanisms to which employers are subject in carrying out those statutory duties. What I've referred to as this rebalancing intended by 669 was evidently directed to ensuring that any breach of those duties would be actionable by claimants if, but only if, it also amounted to a breach of a duty of care owed to a particular claimant in any given circumstances, or in other words, if the breach was itself negligent. She went on to say, it's no longer enough to demonstrate a breach of the regulations. Not all breaches of the statutory regime will be negligent. Before the 2013 Act, the statutory regime had produced results in which employers were fixed with legal liability for actions, even where they had taken reasonable precautions against them. Now, of course, the sort of thing that she's talking about there are the Stark and Post Office type examples of strict liability. And that approach that she adopted seems to be reflected in the opinion of the editors of Monkman on employers' liability, which said that the sole legislative goal of Section 69 was to neuter certain duties. And the editors also made the point that the reason that these strict duties weren't individually amended or repealed is because that task was considered to be too complex, which is an interesting comment because His Honour Judge Alan Gore QC considered or questioned the correctness of the Cockerel decision, albeit in obiter dicta remarks in the case of Tompkins and Tapp, which is a 2018 case. And he effectively said that if breach of the regulations did not amount to negligence, the result would be to emasculate the statutory duties, which couldn't have been parliamentary intention. However, I don't think those operative remarks can really be relied on. And it doesn't make that much sense to have a situation where strict liability, such as in Starker Post Office, amounts to negligence. So my view is that breach of the regulations isn't in of itself ipso facto evidence of negligence, but the regulations will continue to inform if a duty is owed, and if so, the standard of care owed, which is really what Cockerel and Kennedy, which is the other case on this slide, suggest. Finally, just whilst talking about workplace accidents, just a brief comment about causation, because of course you should always ask if there has been a breach of duty, whether or not it's causative. For example, if you accept a breach of duty of care to undertake a suitable and sufficient risk assessment has been breached, then you should ask whether that failure caused the accident or caused the injuries, because of course it may not be causative if control measures that would have been identified in a suitable and sufficient risk assessment were actually already in place. That's just by way of an example. Of course, in that kind of scenario, defendants will be on the back foot, but not in an impossible situation necessarily. Just going to move on to briefly consider contributory negligence. I say briefly, but I actually realise I've got about 3 or 4 slides on this, so it's maybe not as brief as I may have initially had you believe. Anyway, again, I'm just going to look at it in the context of workplace accidents in particular, because it's too large an area to consider throughout, and I want to get on to considering heads of losses and some practical guidance. But just in terms of the workplace, what's really the starting position is that the claimant is supposed to be protected from harm. And when we look at various cases, it's quite clear that carelessness of employees as claimants is treated far more leniently than negligence of an employer, or negligence of a fellow employee for whom the employer is vicariously liable. There's one case which is of particular note, is a case of Caston and Spot Mix Limited. It's a 2017 case heard in the Court of Appeal, or went to the Court of Appeal. In that case, the claimant's hand was trapped in a moving conveyor belt when he was cleaning a vertical surface immediately below the conveyor belt. And this was the defendant employer's standard procedure, which the employer had effectively allowed their employees to do for ages. Now, in cross-examination, the claimant accepted that this was a dangerous procedure, albeit with the impermissible benefit of hindsight, but also accepting common sense. The first instance judge relied quite heavily on that admission by the claimant, and he found liability attached, but that the claimant had contributed to the accident to the extent of 10% through his own negligence. On appeal, the Court of Appeal overturned that decision and found there was no contributory negligence. And in doing so, focused on the fact that the claimant had been adopting a practice that had been adopted by fellow employees. So effectively, and counsel had to accept this during judicial questioning during the appeal, had to accept that what the claimant was doing, if that amounts to negligence, then every single employee doing exactly the same thing as him also amounts to negligence. And they also made the point that the claimant wasn't acting on a whim. So what can the defendant do, or in what scenarios is a defendant going to have better luck in establishing that the claimant has been contributory negligent? Well, factors in the defendant's favour will include things like arguing that the claimant is an experienced worker who's acted contrary to known instructions, or the experienced worker has taken an obvious risk contrary to standard practice which he knew or ought to have known about. One example of this is the case of Sherlock and Chester City Council, where an experienced joiner had asked for a mobile saw to be put in a place so that he could use it. And he was using the bench saw when, without the benefit of a runoff bench, which it was taken he really should have had and should have known that he should have had. At first instance, the claim was dismissed. On appeal, the liability decision was overturned, but with a 60% finding of contributory negligence, which I think we'll all agree is quite a large level of contributory negligence, especially in workplace type cases. And as Lord Justice Latham held, Where the risk has been consciously accepted by an employee, it seems to me that different considerations may arise. That is particularly so where the employee is skilled and the precaution in question is neither esoteric nor one which he could not take himself. So that's an example where the claimant has been held to be contributory negligent in a case which did involve losing limbs. I'm going to move away from liability considerations. And I'm going to go on to discuss some common heads of loss that you may see in cases which involve loss of limb. Before looking at the specific issues, and I should say that on this slide, we obviously have some examples of the common heads of loss. I'm not going to go through every single one of them. I'm just going to focus on a few of them which may be of particular interest. But I've just given some examples there of the sort of things, the sort of heads of claims that you're probably seeing in loss of limb type cases. Before getting on to any of the specific types of loss, it's worth just reminding ourselves the basis of assessing quantum. As Lord Blackburn said in the 19th century, you should, as nearly as possible, get that sum of money which will put the party that has been injured in the same position as he would have been in if he had not sustained the wrong for which he is now getting his compensation, i.e. the whole but-for scenario. The test is slightly more nuanced when considering what aids and equipment are required. A prosthesis is never going to replace a limb, for example. And as we know, some prostheses are exceptionally expensive. So is it reasonable to allow any prosthesis on the basis that without every single type of prosthesis, a claimant is not going to be put in as nearly as possible the situation he would have been in but for the accident? Well, the answer to that sort of problem is found in the case of A. Powers Health Board. That's where a case where Mr. Justice Lloyd Jones held, and the quote's on the slide, but where you have the claimant is entitled to damage to meet her reasonable requirements and reasonable needs arising from her injuries. In deciding what is reasonable, it's necessary to consider first whether the provision chosen and claimed is reasonable, and not whether objectively it is reasonable, or whether other provision would be reasonable. It's quite telling, a very claimant-friendly test. It goes on to say, accordingly, if the treatment claimed by the claimant is reasonable, it is no answer for the defendant to point to cheaper treatment, which is also reasonable. So as I said, on the face of it, it's a fairly claimant-friendly basis of assessment. And it also shows that a claimant who already has a prosthetic plan in place, or a care plan for that matter in place, it is going to be in a strong position to recover the sums of such plans, even if a cheaper alternative is proposed by the defendant, provided, of course, that such plans are reasonable. And obviously, having touched on it, that test is directly applicable to claims for prosthesis. And of course, the question really is the prosthetic plan that the claimant has in place, if he has one in place or she has one in place, is that, and what they're claiming as a result, reasonable? And claimants will almost always have an advantage from defendants in respect of prosthesis claims, because of course the claimant will have a treating prosthetist who makes recommendations to the claimant, and in addition to that, we'll then have an expert who's likely to either agree with that prosthetic plan or suggest that further prostheses are actually reasonably required. And as anybody who does this type of work will be more than well aware, quite often the treating prosthesis is also an expert in other cases and vice versa. And you have this funny situation where they actually prefer to be the treating prosthetist because that enables them to then be being the provider of the prosthetic plan. Defendants, in contrast, are unlikely to have an expert in place until after the claimant has already started down the prosthetics plan. And so it'll be difficult for the defendant to successfully argue that what has been chosen isn't reasonable. Difficult, but not impossible. Obviously, it will involve expert evidence, but the difficulty has to be accepted. Of course, it is for the claimant to prove that any plan is reasonable, but the nature of such claims is that the defendant really will have to put forward evidence to show why a particular plan adopted by the claimant isn't reasonable. Now, obviously, thanks in part to armed forces charities and to insurance companies meeting personal injury claims, there have been extraordinary advances in prosthetics worldwide, but specifically in the UK. And if we just need to look back at the prostheses that were being proposed 5 years ago, let alone even further back than that, to see how they've developed and improved. And of course, the costs of newly developed prostheses can be very high. And having said that, equally, you can have accidents that the prosthetics that we're looking at may well decrease in cost as they're put through the manufacturing process. Of course, the counter argument to that, that the prostheses are going to reduce in value, is that there may well be further improvements and that the cost of the further prostheses, which will be reasonably required to meet the claimant's needs, are going to be a greater cost. So in that scenario, you could argue that what's being sought is actually the good multiplicand for the future prosthetic plan. And of course, multiply and multiplicand approach is meant to factor in future values of a multiplicand. One thing just to focus on, of course, if a claimant has been accessing prostheses through the NHS, then there's no argument to the defendant that the claimant should continue to do so. A defendant can't argue that a failure to obtain prostheses through the NHS is a failure to mitigate. And in any event, such prostheses that are available on the NHS are almost always of a lower standard than can be obtained privately. In terms of the types of prostheses that you can get, they can be either cosmetic, such as silicone digit prostheses, and you'll have cases where if people have lost fingers, they'll be wanting to have digits for winter and for summer because of tanning. Or potentially they may be wanting that. But prostheses can also be functional as well, such as the drivers that we see. For example, drivers with mechanical fingers, which enable claimants to grip and do work. I mean, just from my own case history, I've had a case where the claimant had one of these 4-digit MCP drivers, which enabled him to catch an American football, which when you see it on video is quite extraordinary. And in addition to that, they can do more delicate, finer actions. In terms of assessing the cost of prosthetics, different prostheses for different uses will often be reasonable. Most claimants will have a reasonable need for different types of prostheses depending on what they are doing. For example, one example from my own personal life is that my cousin sadly had to have a below knee amputation at the age of 18, and he is a keen skier. And he's just been provided with a prosthesis that means he can now go skiing, which is an extraordinary thing. And of course, if you have a claimant who goes skiing every year, it's going to be difficult to argue that it's not reasonable for him to have a prosthesis that allows him to continue skiing. Of course, what is reasonable for each claimant may differ. For example, it may be that despite recommendations, the claimant doesn't use any of the silicone digits that he's been suggested because he chooses not to wear them. Similarly, what is reasonable at any given time may well change. For example, if there is a deterioration in mobility anticipated in the future, such that at some point the claimant is going to be wheelchair bound or likely to be wheelchair bound, then that claimant is no longer going to need ankle or knee prosthesis, just by way of example. An example of courts and how they look at prosthesis claims can be found in Miller and Imperial College Healthcare NH Trust, which is on the slide in front of you, where His Honour Judge Curran QC, who was sitting as a High Court judge, assessed quantum, and including quantum of prosthesis, and in his judgment held that the more expensive prosthesis which was being put forward by the claimant was reasonable, and because it met the claimant's needs, and said in doing so that this was due to the fact of the unquestionable advantage in overcoming her disability by the provision of that more expensive prosthesis. That was despite the claimant doing well for a period with a cheaper alternative. And interestingly, in that case, the judge looked at video footage and said it was easily seen and verifiable when you looked at the claimant using the more expensive type of prosthesis in the video, that it was unquestionably more advantageous to her. And in reaching that decision, the judge relied on the case of A in Powers, which is a case which we looked at earlier. The judge went on in that case to find that the replacement of a prosthesis at 75 was reasonable, despite an increased reliance on a wheelchair. In doing so, said the claimant is entitled to be in a position as close to that she had before the defendant's tortious conduct rendered her disabled. What's not on the slide, but which is possibly worth also noting, is that when the decision was that when the claimant reached 82, there was only a 60% chance of her needing the more sophisticated prosthetic and a 40% chance of needing a lighter one. And so it became a sort of loss for chance type situation. And so she was awarded 60% of the cost of a replacement, of the more sophisticated replacement, and 40% of the cost of the lighter prosthetic at the age of 82. The interesting case to have a look at if you have the time. A common question in claims for prosthesis will be, how often should the prosthesis be replaced? Obviously, this will be something that experts will give evidence in relation to. And it's quite often a compelling answer to point to the warranty period, because these prostheses will have a warranty period. Of course, warranty periods are based on normal use. It may be that your client or the claimant, if you're going to sue the defendant, is more reliant on the particular prosthesis. For example, if he's using it for manual work every day, in which case the warranty period may not be the period to use. But it may well be that they're going to use the prosthesis less. For example, somebody who only uses a cosmetic prosthesis for rare social outings, in which case the replacement period will probably be, or should be, longer than end warranty because of the usage being lower. Other matters on this slide, I think I've already touched on. So I will move on to the next slide. And this slide talks about interplay of common heads of loss. Now, defendants may want to consider allowing for an expensive prosthetic plan. The reason for doing so is, as I said earlier, it's often difficult to argue against this if it's already in place. But if it is in place, the defendants can then argue that the success of that prosthetic plan means that the care claim should be limited and/or loss of earnings claim should be limited. And it can often be the case that residual earning capacity of a particular claimant is not affected by the loss of a limb if there is a very successful prosthetic plan in place. And that consideration leads me nicely on to considering loss of earnings claims in a bit more detail. Of course, first question is going to be disability. And in order to utilize the Ogden future loss of earnings calculation between disabled and non-disabled, you obviously have to satisfy the three tests, which are that the claimant has an illness or disability for more than a year, or a progressive illness, and satisfy the Disability Discrimination Act 1995 definition, not the Equality Act 2010 definition. As we know, it's been reverted back to the 1995 Act. And that definition is that the impact of the disability has a substantial adverse effect on the person's ability to carry out normal day-to-day activities. And has to satisfy the third limb. So it has to satisfy those two limbs, but also that the effects of the impairment limit either the kind or the amount of work the claimant can do. Now, when considering disability, I think it's important to bear in mind Section 6.1 and Section 6.2 of the Disability Discrimination Act, which effectively says that the successful use of prosthesis does not mean that somebody is not disabled. And for the same reason, I would suggest that the successful use of prosthesis should not, in my view at least, impact on the third limb of this test. Instead, you should be asking, without the prosthesis, does the disability impact on the kind or amount of work the claimant can do? Now, it's going to be a rare case where there's been a loss of a limb where does not amount to disability. In terms of this slide reflects those comments, so I can move on. In terms of car claims, which is another loss I'm just going to touch on, mainly because car claims in cases where there's been loss of limb can end up being large. Adaptations to cars can be costly. Obviously, requiring a wheelchair accessible car can lead to a large loss. Even a claim based on having to go from a small car to a large one can become a large claim when you factor in the cost difference between a small and large car and the number of replacements that will be required in the future. And of course, the increased costs of running a large car, for example, petrol. I'm not going to discuss how to calculate those types of claims in any detail. There is, I would identify some good assistance in facts and figures, which sets out averages and also basis of calculating these type of claims. When looking at averages, I would obviously caution that it's much better to have actual evidence of the difference in cost. So if you have actual evidence of the cost of the car that the claimant was running before the accident and actual evidence of the car that the claimant will require or has now required as a result of the accident, that's going to be much more compelling evidence than looking at averages for obvious reasons. And also, I would just mention one cautionary note in terms of claiming the difference between automatic cars versus manual cars. Firstly, many car makers are now moving away from manual transmissions in any event. So the likelihood of running or needing or not having an automatic car in any event is obviously limited. Also, there's conflicting evidence whether automatics are in fact more expensive to run. So if that is a claim that you want to pursue, as I've just said, much better to get actual evidence in terms of the basis of the difference in the costs. I am just going to touch briefly on the Motability scheme. Now, you may have a case where the claimant has become wheelchair bound or needs a Motability scooter or something along those lines. And such a claimant may have accessed the Motability scheme ahead of any determination of quantum. Especially one where liability is still an issue, of course, because they may not be wanting to incur costs unnecessarily if liability is still at large. To be eligible for the Motability scheme, you need to have at least 12 months of DWP mobility allowance left, and that allowance has to fall within the second schedule of the Social Security Recovery of Benefits Act 97. Obviously, I would just note that DLA is being replaced by PIP, so only those receiving the enhanced rate of mobility components of PRP will be eligible, and that's for the future. In terms of options under the scheme, you can either get a scooter or a car. It might be cheaper, of course, to use the allowance that you have, or that your client has, or that the claimant has. It might be cheaper for them to use taxis if they're not doing enough travel by car. The claimant doesn't have to be a driver. And in terms of the options, the claimant can get a new car on a 3-year lease, or for those needing wheelchair access, you can get a new wheelchair accessible vehicle on a 5-year lease, or a second-hand one on a 3-year lease. Or they can get a powered wheelchair or scooter on a 3-year lease. If the claimant has a mobility allowance, can the defendant argue that the claimant should access the Motability scheme rather than go through the more expensive approach of paying for it privately? Well, the answer definitively was given in Eagle and Chambers number 2, which effectively said no. In this case, what the Court of Appeal commented on is Section 17 of the Benefits Act says that when assessing damages, the amount of any listed benefits paid or likely to be paid is to be discarded. Now, in this case, the claimant claimed loss of mobility in the future beyond 5 years, so there was no reduction of damages referable to any crew certificate. And the Court of Appeal held, as I've quoted on the slide, that prima facie, it seems to me that a rule as to mitigation can be said to be a rule relating to the assessment of damages. If that is so, on its language, the section precludes an insistence that any of the benefits set out in Schedule 2 to the 97 Act should be used in any way to mitigate loss. And that's what was Lord Justice Waller who said that. So a defendant cannot argue that the claimant should use the motability allowance to participate in the motability scheme. Another head of loss, another head of damage that's often seen in loss of limb claims involves accommodation. This may well be one where expert evidence from an accommodation expert is required. The claimant's claim, it may just involve adapting existing property, which could be fairly straightforward claim set out, because you'll have the cost of adaptations as evidence for past expenditure, and you may well have future quotes for future expenditure. Of course, you may need expert evidence in terms of what adaptations are reasonably required to meet the claimant's needs, and that may come via either a care expert or from an accommodation expert, or from an orthopedic expert for that matter, depending on the scenario. Where it's reasonable to need to change houses, then the calculation is not as straightforward. The Robertson-Johnson basis, the Robertson-Johnson basis for assessing such claims is no longer authoritative guidance, which is how it was described in the more recent case of Swift and Carpenter. And the reason being, of course, is that the negative discount rate meant that it no longer achieved a fair and reasonable compensation for claimants in those types of cases. I've done my best to set out on this slide and the following slide the equation that you now have to use in such claims. What you effectively have to do is work out what the value of the property required is. That gives you your P value. And then work out the value of the property owned but for the accident. That's your B value. And have the particular life expectancy for the claimant, which will be either from multipliers or from, depending on the scenario, maybe from expert evidence. When you have those three values, you can work out what the reversionary interest is by using the calculation on the slide. And that then will give you your R value. You then move, excuse me, I've shot forward. And then to calculate the damages, where D obviously equals damages, what you do is you take the value of the property required less the value of the property owned, and then from that you deduct the reversionary interest, and that gives you the figure of damages. Now, that calculation can be put into an Excel document, and no doubt most of you will have access to something similar that does the calculation for you when you input the values of R, P, B, and L, or not even R, just P, B, and L. So I'm not going to go into any worked examples, which I'm sure you'll be more than well pleased to hear. Instead, what I'm going to do is move on to some practical tips, which hopefully some of which will be of assistance. Going to start off with expert evidence, because it's always important in these types of cases to consider what expert evidence is reasonably required to resolve the proceedings. And that's obviously the test under CPR 35.1. And of course, when looking at the test under CPR 35.1, it's worth just reminding that it is evaluated with the overriding objective in mind, which of course, as we all well know, involves a large consideration towards proportionality. Fortunately, I suspect for claimants in particular, these types of cases are normally quite large. And so proportionality is less of an issue in terms of obtaining expert evidence, which would otherwise be reasonably required to resolve proceedings. You'll almost always have an orthopedic expert in such cases, almost always have a prosthetic expert, and almost always have a care expert. Depending on the injuries, you might also have additional expert medical evidence. For example, phantom pain might require some form of pain management expert. You might have a chronic pain situation arising from or exacerbated by psychological issues, which are quite often common. So you need a psychology or psychiatrist to deal with the impact of the loss of the limb, which can quite often involve an element of PTSD and certainly anxiety, etc. As I've already touched on, accommodation experts may be required, employment expertise may be also reasonably required, although courts are generally less inclined to allow employment expertise, especially when it's just going to be a question of fact. So you need to consider, I would suggest, what expert evidence is reasonably required. And of course, that involves having a look at what symptoms the claimant has. No matter what side on, I would suggest an early review of medical records. Certainly the defendant should be looking to have early disclosure of medical records, and obviously the claimant will have access to them themselves, because that will inform, ought to inform what expert evidence is reasonably required. Of course, just because a claimant obtains expert evidence doesn't mean that the court will, in the fullness of time, agree that it's reasonably required and then give permission. Although, of course, I think as I've already touched on, in large claims, it is more likely to be allowed. But having said that, if a defendant wants to oppose the instruction of a particular type of expertise, my suggestion would be to make it quite clear in correspondence the reasons for that opposition ahead of the claimant doing so. And then set out the basis for that opposition again ahead of any CCMC where permission for the expertise is going to be considered. Obviously, it goes without saying, although I'm now going to say it, you should be setting out why it's not reasonably required to resolve proceedings, and or not why it's within the overriding objective. Similarly, of course, if you're for the claimant and you want the expert evidence that is being opposed by the defendant, you want to set out the reasons why it is not only within the overriding objective, but more importantly, why it is reasonably required to resolve proceedings. As you could probably pick up, loss of limb cases are often expert evidence heavy. And as such, it's often sensible to consider the merits of a split trial if liability and or contributory negligence is in dispute. I've put on this slide some pros and cons in relation to determining whether or not to go down a split trial route. The pros include it might prevent costly expert evidence being obtained before the liability decision. It might mean that liability is determined earlier, therefore giving the parties a more certainty as to offers and the like. Of course, certainly after a liability decision does, of course, remove litigation risk of liability, which might be something that claimants in particular will have a mind to. Although having said that, if a claimant is feeling a little bit uncertain about their prospects of success in relation to liability, they may want to keep it all open. The cons, of course, is that it might potentially delay the final decision, and it removes litigation risk type arguments from negotiations. And of course, it may prevent expert evidence being obtained contemporaneously, and that might be something that the defendants want to have a particular concern to, because by the time the decision to have a split trial is made, it may well be the claimant's already got their expert evidence and the defendant hasn't. And if you're waiting half a year or a year to have a determination of liability, that's half a year to a year when the defendant's not able to go and get their own expert evidence. So those are just some things to weigh in the balance. In terms of what we have on this slide, of course, because expert heavy and because of the costs involved, loss of limb cases can often be costly cases to run and to defend. And defendants may be keen to minimize those costs by having an early JSM, and also that matter to make an early suitable Part 36 offer if they can. And for the claimant, it might be worth bearing this in mind, because it might be that an early JSM is actually beneficial to the claimant because they may have all or most of their expert evidence already in place ahead of the defendant doing so. And so it may be that the claimant's in a better position tactically to attend the JSM and to argue their case. Of course, must caution that an early JSM can be a waste of time and money if there are too many known unknowns. And I've put a few examples of known unknowns on this slide. If you have too many known unknowns and it's going to mean that settling at a JSM is unlikely, then of course it does mean that having such an early JSM is possibly not the most cost-effective thing to do. Now, claimants tactically may want to take advantage of the full 3-year limitation period in these cases, especially if the claimant's solicitors have been involved at an early stage, which normally they will be, given the nature of the type of accidents and injuries that we're talking about. And the claimants, I would suggest, be using this 3-year limitation period to take advantage and get a prosthetic plan in place. Maybe even get a care plan in place if there is a need for care. And certainly to obtain expert evidence ahead of issuing, and not just in one field of expertise, but in the fields of expertise that are anticipated as all being reasonably required. Flip side of that is the defendants may want, if that's the approach the claimants are going to take, defendants may want to try and be involved in both of these matters in terms of they may want to be involved in funding any prosthetic plan, because that will mean that they'll have some control over decisions being made. It's unusual, but it's not impossible for that to take place. But what is less unusual is that obtaining early disclosure of expert evidence, of medical reports, medical records even, to enable some defendants to consider expert evidence requirements, so they can get their own expert evidence in advance of any claim being issued, which of course is permissible. So that's just something to have in mind too. Just moving on onto the types of orders that can be made that you might want to have consideration to. I'm going to talk about provisional damages firstly, and then I'm going to talk about PPOs. In terms of provisional damages, it's often worth thinking about whether provisional damage orders is something that either party might want, but predominantly the claimant. Is there going to be a deterioration? For example, you might have a case where the claimant hasn't actually suffered any loss of limb, but there's a small but measurable risk of amputation in the future. For example, a 15% risk, and 15% of a potentially very large claim could be made on the basis of the chance. But if the 15% chance actually then does happen, then there's a real and significant risk that the amount of money that the claimant has recovered as a result of that percentage will not cover, for example, the new house that's required, or the prosthetic plan that is reasonably required. Obviously, provisional damages avoids or lessens the risk of claimants being undercompensated. It also avoids claimants being overcompensated, because in a lump sum award, which takes account of the percentage risk, if that risk doesn't materialize, then the claimant is going to, as a result, be overcompensated. Historically, insurance companies have preferred the finality of a lump sum. However, it now seems, certainly from my experience, that they're more inclined towards provisional damages being awarded. Some obvious tips include ensuring that CPR, the matters set out in CPR 41.2 are set out. So you also need to make sure you plead the claim and set out all of those matters. Any order for provisional damages needs to be carefully worded because there can only be one application made in the future. So not only does the order need to be wisely worded, but the timing of making that application needs to be considered. Of course, an application can't be made after the time specified in any order. So that obviously means that these things need to be very carefully worded and considered. And that's provisional damages. How about periodical payment orders? I think, personally, that these are a very useful tool in loss of limb cases, where, of course, you'll normally have an identified ongoing annual cost for example, the prosthetics plan, or there may be case management or care needs, which have an identifiable annual loss. It might also be that because of the accident, there are life expectancy issues. And of course, the PPO avoids the risk of a claimant who outlives the predicted life expectancy being undercompensated. And conversely, a claimant may be overcompensated by a lump sum. You may need expert evidence to persuade a court of the need of a PPO, but not always. And by that, I mean expert evidence from a financial advisor. And what they generally do is they talk about the uncertainty in performance of future investments, which actually was what took place in an example case that I'm going to come on to. As with provisional damages, it's important to look to this CPR and make sure that you comply with, in this particular case, CPR 41.8. And that's in relation to if an order is made, to make sure you comply with what 41.8 says that a PPO must specify. There's some other tips here on this particular slide. I think I've touched on some of them. I would also add, of course, that if the defendant admits the requirement of the PPO, then obviously that is a sensible thing to set out in the defence. If they deny it, then obviously that is also a suitable thing to set out in a defence. You should also ask the court for an early indication, because as soon as reasonably practical, the court is meant to give an early indication as to whether or not a PPO or a lump sum is going to be the likely award. And they do that, or the court is meant to do that, by considering all the circumstances of the case and the form of the order that best meets the claimant's need. Defendants often like PPOs that can be varied, less so with PPOs that are not capable of being varied. Of course, if a PPO can be varied, then it may well be that the amount of the figure is reduced in the future. For example, if there's a chance the claimant's condition will deteriorate such that it needs institutional care, which is the example I gave earlier, and therefore doesn't need the expensive care package provided at home, that will obviously reduce any care annual cost. Or there's a chance the claimant's condition will improve. If there's a chance the claimant's condition will improve, then the PPO can be varied. Note the difference here between provisional damages and PPOs, because when the variation here can benefit the defendant. Now, if you want a PPO which can be varied, ensure you set out the reasons for this, for obvious reasons. Any order must specify the anticipated reason for the deterioration or the improvement. Because if you don't specify it and then that materializes, it won't be a ground to apply to vary. In order to vary a PPO, court must first give permission to apply to vary. And that's done as a paper exercise at first instance. The application to vary, or the application for permission to vary, I should say, is decided on paper, having considered claimant's evidence and any written representations from the defendant. If it's refused on the paper, then you can ask for an oral reconsideration. And then if it's refused at an oral hearing, then that decision is final. If, either on paper or the oral hearing, permission to apply to vary is granted, then the application to vary will be heard in a public hearing. And then the CPR 52 provisions in relation to appeals will apply. So if you don't get the decision you like at that application to vary, then you can always seek permission to appeal. I promised the recent case on this. It's probably the most recent case that we have in my talk, bearing in mind that it is from this year. It's the case of Bourne-Arton and Salford. It's a useful case to read when considering whether or not a PPO should be made and how to vary. His Honour Judge Bird, sitting as a High Court judge, held a number of things, and I've got them on the slide. First of all, that the power to vary covers both physical and mental conditions. And then went on to say, before the power arises, there has first to be proved or admitted a chance, i.e. something that is measurable rather than fanciful, that the claimant will develop some serious disease or suffer some serious deterioration to her physical or mental condition. In Bourne-Arton, the court accepted the defendant's request for a verbal order on grounds that the claimant's condition might deteriorate such that would need institutional care. And that is obviously where I got that particular example from. Interestingly, in that case, the application to vary could be made for the claimant's entire lifetime. Just a cautionary note for anybody who thinks this is a good idea. There's no right to vary on the grounds that prostheses will go up or down. What you have to do in these, when looking at the cost of prosthetics, is determine, or the parties have to agree, either the court to determine or the parties have to agree, what the appropriate sum for the PPO is to order to meet that reasonable need, absent the possible deterioration or improvement. So that takes me to the conclusion of the slides, and rather obviously the conclusion of the presentation part of the webinar. amazingly, bearing in mind I've never done that webinar before, I fitted it in within the hour allocated to me with 4 minutes to spare. So I'm going to look rather dauntingly at the Q&A box to see if there are any questions there that I actually can answer. So I'm going to do that. If anybody, whilst I'm looking at this, has any other questions, obviously, please type them in. Otherwise, my email's on the slide there, and I'm happy to I'll take any brief questions by way of email, and I'll do my best to get back to you as soon as I can. Right, so anonymous attendee asks in relation to birth defects rather than a loss of a limb. The question is, does any of this apply for a birth defect rather than a loss of limb? In that, as the person gets older, an absent limb cosmetically or practically may have a bigger impact, and a wish for prosthesis, a possible claim against medical defendant? Well, I mean, the answer must be yes. Obviously, depending on the facts. But if there is a reasonable need in the future, if there's something that's reasonable to meet a need in the future, then yes, of course, you could claim for it. Tanya Ray says, please can you send slides to participants? Thanks. I think they're all sent to the participants that have logged on afterwards, and very helpful. Kelly will be doing that afterwards. In fact, I think the answer has been typed in any event. And not a question, but a comment from Christina. You're very welcome. I'm glad that you enjoyed the webinar. If anybody else has a question, either tap it in now, 2 minutes to go, or, as I said earlier, just send me an email. I'm very happy to answer any quick questions rather than providing detailed advices, of course. Excellent. I think I'm off the hook. There's no other questions that are being raised, so I will stop asking for them. And in present case, we'll just simply say thank you very much for all attending, and thank you very much. Have a good week, and hopefully see some of you soon. Okay, bye.